Less than an hour before the Namibian constitution turned 35 years old, Namibia's founding president, Dr. Sam Nujoma, passed away. Under Nujoma's guidance, late President Gôagoseb led the Constituent Assembly. They had the mammoth assignment to craft the Namibian constitution within approximately 80 days. Today, 35 years ago, the supreme law of the land was born, having paved the way for what was to become the constitutional dispensation some 6 weeks later. This evening, in this special tribute broadcast honoring the life and legacy of Dr. Nujoma, we pay homage to his contribution to the Constitution, constitutional democracy, as well as the rule of law. Greetings to you, Namibia. I'm Ricardo. Gôagoseb. Now, I'm joined in studio just for this engagement by one of course, our scholars, academics in the field of law. That is Professor Dunia Prince Zongwe, Associate Professor at the School of Law at the Faculty of Commerce, Management and Law at the University of Namibia, to really reflect on this important day and the contributions by the late president in terms of constitutional democracy and the development of the rule of law. Very good evening to you, and thank you so much, Professor, for making time out to join us.
Yes, good evening, and thank you very much for having me.
Well, Prof, of course, we had initially planned to have this conversation to really just focus on Constitutional Day when we were met with this news early in the morning of the passing of the late president. Perhaps how did the news find you, and what were some of your initial reactions to it?
Well, I mean, the founding father, President Sam Nujoma, was, like I've just said, the founding father. So my first thought was that this is a great loss. Also because President Nujoma was also the father of constitutionalism. We take this for granted, but if you look around on the continent and elsewhere in the global south, you notice that countries have constitutions, but they do not have constitutionalism.
I think just draw a parallel for us between those two. Just, you have the constitution, but what exactly constitutionalism itself means? Well,
it's not the same thing. The Constitution is a written document that, on this, for example, Constitution Day we are going to talk about, the one that was adopted on this very day 35 years ago. But constitutionalism is about constraining the power of government, of the executive or the state. And this, to understand the contrast between the Constitution and constitutionalism, you have to look at jurisdictions like the United Kingdom, where they do not have a written constitution, but they do have constitutionalism. So there's a number of constitutional conventions that restrain the power of the state. So on this day, 35 years ago, Namibia had a written constitution, but it was not a given that the state would have complied with the provisions of the Constitution. So it is a true, I think it's a recognition of President Nujoma's legacy, that he chose, because it is a choice, and a courageous one, he chose to abide by the provisions of the Constitution, even though, for example, in some cases, the decisions of the courts did not favor the government. So that's why I'm saying that in terms of the Constitution, there was constitutional leadership. He was the chief implementer of the Constitution. And as an academic from the University of Namibia, I should also highlight the fact that President Nujoma was also the founding chancellor of the university, and in that capacity, he really steered the university in the early stages. And at the inception, of the university, even made this declaration that he hoped that the university would bring together dedicated women and men of quality who would help uplift the living standards of the Namibian people.
Well, some would, Prof. Zongwe, some would contend that it is far from insignificant that the former president, of course, passed on the anniversary, the 35th anniversary of the Constitution of the Republic. Let's take a step back and reflect on its drafting and how it was put together. Of course, we know initially when the Constituent Assembly was formed, there was really no constitution. There were different varieties going around. Each political party had its own. And finally, they adopted to say, look, okay, let's rather take the draft of SWAPO party and then build on that as well. Let's talk about just the Constitution and the constituents assembly and how it was put together. And of course, different representatives, different political parties, different ideologies. Just reflect a little bit on how they came together, the Constituent Assembly, and just that responsibility of making sure that we need to find common ground on many of the issues that were included in the Constitution.
Well, it's an interesting historical moment in the sense that I remember even Professor Disho in his book, The Namibian Constitution in Perspective, raised this issue in the sense that already before the Constituent Assembly, before it was put in place, the Western Contact Group, which was a group of Western countries, the United States, Canada, the UK, France,
UK, USA, and France, I think,
exactly. They had adopted on the Chapter 7 of the United Nations Charter, they had adopted what is called today the 1982 Constitutional Principles. Those were that was the basic architecture of the Namibian Constitution. It's true, like you said, that the SWAPO Constitution also was heavily influenced the Constitution, but the basic architecture was already decided. The question was that because it was decided by countries other than Namibia, to what extent we could say that the Namibian Constitution was written by Namibians. So the process itself of drafting the Constitution took about 80 days. It was considered to be a bit rushed compared to the Constitution making process in other jurisdictions, but it nonetheless produced a Constitution that is regarded as one of the most progressive on the continent. So the chairperson of the Constituent Assembly was the late President Hage Geingob. There were 21 members in that committee, 6 women, and their job was to draft. They were responsible for the drafting of the Constitution, but it's important to note that the actual drafting was not done by that committee. It was done by 3 South African lawyers, Arthur Chaskalson, Erasmus, and Marinus Viras. So those 3 lawyers did the actual drafting, but the conception was done as early as 1982. And then it was improved by the SWAPO Constitution and the input of the members of the Constituent Assembly. Yes. So another, since we are reflecting on the legacy of the founding president, Sam Nujoma, it's also important to mention that one of the achievements that he made was to basically make the Constitution, make people assimilate the Constitution, make it their own, because it was not evident. As I said, the book that I was referring to by Professor Disho was written in 1992, and then at the time already there were questions as to the extent to which the Constitution reflected Namibia, the priorities of Namibians, etc., etc. So,
in terms of that, I think one of the most important things that I really take from the Constitution is the preamble.
Yes.
And the preamble really takes it. I want to really quote it because I don't want to get it wrong. Whereas the recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is indispensable for freedom, justice, and peace. And becoming sort of like a cornerstone of the Constitution. Talk to us about the importance of the preamble and it laying the foundation for this new nation that is being born.
Well, the preamble has an important role, especially in the interpretation of the Constitution itself, and in also reciting the foundational values of the Namibian society. You mentioned justice and peace. The very first article of the Namibian Constitution, Article 1, Sub-Article 1, makes it very clear that the Namibian state is founded on 3 principles: rule of law, justice for all, and democracy. So the idea of justice is very important, and it's again reflected in the preamble. There is also other, the preamble also recites, it gives the historical background of
where we come from as a people and why it has to be structured in this particular manner. Yeah.
Exactly, apartheid, etc., etc. And also its adherence to global standards such as the Universal Declaration of Human Rights. Yes.
Talking about that Universal Declaration of Human Rights, it's also one of, if you look at chapter 3 that speaks about those inalienable human rights, a very distinct feature that was put into the Constitution as well. We know, of course, it's a very, very special chapter because you cannot amend those rights negatively. You can only amend them positively. Talk to us a little bit about the inclusion of that, looking at the historical or the history of the country and of the history of oppression and where we came from as a people.
Well, chapter 3 embodies the struggle, the liberation struggle, and the things that we're fighting for: dignity, equality, and other values like personal liberty, given the arbitrary arrests that took place during the apartheid areas. It cannot be, like you said, negatively changed. The provisions of chapter 3 are also entrenched, although one of the points I remember even one of my lecturers was mentioning was that when I was a student was the fact that the entrenchment clause of the Namibian constitution itself is not entrenched. So that's the irony. So somebody can change that entrenchment clause and so forth, but it's not likely that the courts will accept that, because it's very clear what were the intentions of the framers of the Namibian constitution and the members of the Constituent Assembly. So yes, it is entrenched and cannot be changed, unless theoretically the constitution itself were to be replaced by another constitution.
Well, if you look at it there, I think a couple of provisions that I wanted us to just pay a bit of special attention to as we're reflecting on Constitution Day. We know very, very important one, of course. Article 1 speaks about the establishment of the state, but Article 6 speaks about the protection of life. Looking at where we are coming from, of course, the question around capital punishment was also quite a big one. And understanding it was a serious debate with the Constituent Assembly, where they even had to bring in the Council of Churches of Namibia really to contribute to inclusion of this clause. Reflect a little bit on that one for us, around the protection of life and why that was one of those big debates during the drafting or the framing of the Constitution.
Well, the protection of life was, again, for historical reasons, and again, with the input of different stakeholders, they decided not to include the death penalty. And I would even add that it's also a reflection of African ethos and Namibian ethos, in the sense that if you think, for example, of it in terms of Ubuntu, life is sacred. And combined with the idea of human dignity, you would understand why the Constituent Assembly eventually decided not to have the death penalty. Life imprisonment is punishment enough from that perspective. And the idea of Ubuntu had two major aspects: the one of humaneness and humanness, and those are the values that eventually, when they were discussing about whether to keep Article 6, whether to keep the death penalty or remove it, those were the values that and the considerations that they took into account in coming to the decisions of not including the death penalty.
Quite important ones, of course, and really also reflection of the time was Article 11 and 12. 11 talking about arrest and detention and fair trial. Quite important because of what was happening with the security forces, the internal security forces. Of course, the police were the enforcers on behalf of the apartheid government. And in Article 12, it really speaks distinctively around, providing very detailed, 48 hours you have to appear before a court of law. Your family, even in a criminal procedure, having the authority now to, if they haven't seen your body, for example, if you've been detained, family even has the right under the habeas corpus maxim to be physically shown the body, for example, of someone that has been detained. Talk to us a little bit around how some of those provisions were very detailed and practical, but were necessary when they were included. Well,
it was necessary once again because of the history of the systematic discrimination that took place during the apartheid days, where black Namibians would be arrested arbitrarily. Article 11 and Article 12 actually reflect global standards. If you look at the International Covenant on Civil and Political Rights, you will find those same standards: the habeas corpus, the privilege against self-incrimination, the presumption of innocence. All these standards are found in the International Covenant on Civil and Political Rights, which is a UN treaty. Those global standards influenced Article 11 and 12, but they are not the only source, substantive source of those articles. History, the Namibian history, and the abuse of the state power also informed the inclusion of Article 11 and 12 in the Constitution. Let me also mention that the 1982 constitutional principles, in the principles that they were advocating for the Namibian Constitution, there were also guarantees around the Bill of Rights and fair trial. So yes, those are the different sources that influenced, substantive sources that influence Article 11 and 12. Yes.
In terms of that, quite an interesting thing is, of course, also because it also places, particularly for Article 12, it places a burden of responsibility on the government as well. Because if you cannot afford legal representation, then one will be provided for you, obviously, at state expense, basically. Talk to us about how that really promotes the access to justice for all Namibians.
Well, yes, it helps in terms of access to justice, but let's say that the budget of the Directorate of Legal Aid, as we know, is not sufficient. But when you talk about representation, legal representation, I think the leading case here is the Mulima case that was decided by the Supreme Court. And in that case, the court decided that because of the complexity of the case, the great number of accused involved, and the interest of justice, then the Namibian government had the duty to provide them with legal representation. I mean, this is another piece of evidence of the legacy that President Nujoma has left behind. The idea of constitutionalism, where the judiciary tells the government that here, if you do not provide legal representation, there would be a miscarriage of justice. And the government, despite the fact that the Capivi accused were basically challenging the constitutional order, the government nonetheless complied with the court order. And that is one of the legacies in terms of constitutionalism that both the founding president, President Nujoma, and the late President Gôagoseb have left behind.
Prof. Zongwe, you spoke, I think, at the beginning when you were explaining the importance of constitutionalism, really that it's putting a limitation on state power. And we see that with the establishment of the state, the three branches of government, executive, legislature, as well as judiciary. We know the one important thing and one of the problematic issues or issues that were being debated is whether the president should be a ceremonial president or an executive president. But let's talk to us a little bit around the selection was to go with the executive president, but to put limitations on the power with the separation of the branches, the three branches of government, legislature, judiciary, and executive. Talk to us a little bit around the importance of that separation of power and the legacy that the president leaves behind by adhering to, like you said, some of the outcomes from the judiciary, some of the decisions that are made by legislature, etc., during his tenure as president.
Yes, it has a long history when you think about the separation of powers, although, like I quickly mention, the Namibian judiciary has yet to come up with a coherent doctrine of the separation of powers. It has a long history, but one of the famous formulations was by the French jurist Montesquieu, who said that in order to basically constrain prevent the arbitrariness of power, you needed to separate state power into three branches, judicial, legislative, and executive. And it's also reflected in the provisions of the Namibian Constitution, including Article 1.3, that talks about the different branches of the Constitution. So regarding the executive powers, as you said, the president in Namibia is not a ceremonial president, it's an executive president. And the powers of the president were increased with the Third Amendment in 2014. So it is a powerful president, but its power, I mean, his or her power are actually constrained by the legislature and the judiciary. And the judiciary on several occasions and several decisions have, for example, held the decisions made by the president to be unlawful or illegal. So I remember that one of the recent cases involved the regulations, I mean the proclamation made to respond to the COVID-19 pandemic, the Namibian Federations of Employers Federation took a case to court in order to have some of these provisions declared unconstitutional. And this is just an example among many of how the judiciary checked and balanced the powers of the executive. Yes.
I think the one thing I really want to just touch on before we close off our conversation really is the amendment of the Constitution. And generally they say that, look, it's a living document, of course, but you don't want to, because it's a supreme law and there's, even from an interpretation of statute perspective, you don't want it to be touched too much. Just to reflect a little bit on we had only 3 amendments so far to the Constitution. If you can reflect to it within international best practice, where we stand as a country and whether it really shows the quality of the document that we have, for lack of a better word.
Yes, well, if I were to start with the last point that you made in terms of, let's say, global, comparisons, Namibia fares pretty well. I mean, if you think about it, research conducted by empirical research conducted by American scholars showed that the average age or life expectancy of a constitution is about 19 years. 19 years, and the Namibian constitution has turned today 35 years. So that already shows you that by global standards, Namibia is doing fairly well. In Europe, it's 32 years, the average, and Namibia is 35. It's another, it's another piece of evidence showing that about the, let's say, the maturity, the constitutional maturity of the Namibian leadership, but also the political stability. In Africa, there's only 3 countries that have older constitutions, and that is Botswana in 1966. That's when it was adopted. Mauritius, 1968, and also Tanzania in 1977. So this longevity is rare in Africa. So in Africa, the average age for the constitution before it gets changed is about 10 years. To give you an example, between 1960 and, to date, a country like the Democratic Republic of the Congo had about 7 constitutions. In 35 years, Namibia had only 1 constitution. So it is evidence that Namibia is politically stable. It has a constitutional democracy because a dictatorship will not be able to keep a constitution for that long. So yes, so by global standards, the Namibian constitution is pretty remarkable. So it is. It's one of the legacies. I mean, if we were even to sum up this conversation and say what is the sign or the marker that the founding president Sam Nujoma and the late President Gôagoseb have achieved in their task to create a stable and inclusive society, it would be the fact that the constitution has lived for so many years. We shouldn't take it for granted. Just look around when the constitutions were adopted in different countries, on other continents as well, and you'll see that 35 years, it's remarkable.
It's quite a time.
It's quite, yes.
Prof. Zongwe, thank you so much for making time out to join me.
Okay, thank you very much for having me on the show.